self-refusal. So according to the law of Ukraine of the Constitutional Court of Ukraine and the provision of the advisory group of experts, the deputy member Volodymyr Kuzmenko is fulfilling the powers of Yaroslav Romaniuk on the assessment of the candidate Volkova. Also, the deputy members of the present here, Thomas Griffith, Richard Barrett, Mark Zubik, and Vasil Shakun. First of all, I would like to thank you, Olena, that you agreed to participate in the interview and answer our questions. And also, I would like to inform you that the advisory group of experts has thoroughly studied your documents that were submitted in line with the requirements, and also learned other documents that were received from certain institutions and also from the public. And today we are holding the interview in order to clarify certain moments that are connected with the possible, probable doubts, and in connection with the questions that we'll ask you and also your answers. We either debunk these doubts or confirm it. So please have the understanding to the act of our interview. We are conscious that you are an honorary person in our society, that you have significant gains in your professional activity, and of course, just like other candidates, you can be the candidate for the position of the Constitutional Court judge. Also, I would like to inform you about the regulation and normative base. The interview is one of the mandatory stages of the assessment of the criteria of high moral values of the candidate. The advisory group is conducting the interview with the candidates in accordance with Article 7, the methodology, and in order to explain the doubts I have just mentioned on their high moral values. During the assessment of the material about the candidate Volkova, the expert of groups have forwarded her questions for the written answers, and pay attention that in accordance with Part 8 of Article 7 of the methodology, the candidate cannot provide the information, documents, or any other materials during the interview. If the advisory group has sent the inquiry on their provisions sooner and the candidate didn't provide them in the outlined period, or if the candidate could provide them on their own initiative earlier. Altogether, the advisory group can make an exception if they draw the conclusion of the reasonable exception. Also, I would like to inform you that we are recording this interview, and we have the streaming online on the website of the Constitutional Court of Ukraine. Also, pay attention that the restrictions of use of sensitive information and data streaming online. So, dear candidate, pay attention. The duration of the interview is around 1 hour. The norm of answering the questions up to 3 minutes. So please be to the point, clear, and stick to this regulation. At the end of the interview, you will be given the possibility to make the final speech up to 5 minutes long. And I would like to remind you that the advisory group informed you in advance about the existence of doubts following the evaluation of compliance with the criterion of good moral character. And the purpose of this interview is to disapprove any doubts about your good moral character. So, colleagues, we are starting. Please pose questions to Olena. Thank you.
Доброго дня.
Thank you very much for appearing before us this morning. We look forward to asking you questions and giving you the opportunity to talk with us. If at any time you don't understand a question, please make that known and we'll try to clarify. I will turn the questioning over for the first set of questions to my colleague, Mr. Kuzmenko.
Доброго ранку.
Thank you. Good morning or good day. I would like to join to the words pronounced by my colleagues. Our task is to clarify in that big chunk of information that we got certain conditions, doubts that were in the previous conclusion that you obtained, and I hope that you will help us with this. So let's start with a question. So question 1 refers to disciplinary action in 2018. And remember, the first disciplinary chamber instituted disciplinary action against you and imposed disciplinary sanction on you in the form of filing a motion for your dismissal from the judicial office. And sent you for the studies, and you were referred to the National School of Judges. But I know it's not very pleasant, but could you please tell us in more details what led to such a measure? Thank you. Dear members of the advisory group, my judicial career has begun just like for many judges, but in the course of time, there was a question that challenged my life. There was the case, the collegial case under my consideration, on account of which I had to refer for the protection to the Council of Judges. It was 2009, 2010, I suppose. And I referred there, and I have changed. I started separating from other judicial community. I was aware of this, and I could feel it. Despite the dignity revolution, there was the weakening on account of me. I would like to clarify. When I sought for protection for my minor child and myself, unfortunately, the decision of the Council of Judges was on the level of my region, and it was not satisfied. I think this was due to corruption component. That's why you are present here today, and I am present here today, and I'm giving you these explanations on this account because the judicial system that we had was old-fashioned, and the old Olena Mykolaievna, so sorry. Do you remember the regulations and the timeline that was mentioned? We would like to hear the answer to the question, given that you have 3 minutes. I'm so sorry. I got distracted a little bit. Indeed, it happened in such a way that there was the situation that made me to be in the face of the cold effect for years. After the revolution dignity, it got better a little bit, and I showed myself as the judge, as the trainer of the National School of Judges. Everything was all right. But later, I had the situation. The new criminal procedure was adopted in accordance with which my legal position, and it wasn't just my legal position, but of many judges of Ukraine, on account of the self-recusal, as the norms of the criminal process contain exclusively the order for giving recusals, but there is no the self-recusal. So if we compare the civil procedure or cassation procedure, there the judge can self-recuse from the consideration of the case. But out of the norms of the international law, as per Article 6 of Convention, the judge cannot be recused by the court. Dear Olena, I'm so sorry. I have to stop you and ask you to answer the questions clearly. We are speaking about the disciplinary liability. And please, could you just explain what was the reason and how you assess this situation? But you give us a very extended information on the status of the legislation, amendments made to it. This does not subject to our consideration, yes, but it's the part of the disciplinary sanction that was used or imposed on me, not using self-recusal. This norm was served as the basis for this, and apart from this, there were false data given that were connected with my non-ethical behavior. So my expression of will, my opinion causes some of my colleagues, makes some of my colleagues indignant when I express my mind. And this situation is very complex. I understand your task And maybe it's hard to speak about my integrity given this situation, but I would like to say that unfortunately the High Council of Justice, my opinion, not to full extent have studied this question. Not to full extent. So the legal position doesn't impact. Even if I had self-recusal, it did not affect any cases consideration. I think it's progressive and necessary for our state, since there will be no abuse and people will not have the status of the accused persons for years, since the self-recusal is used by the parties to the process, the parties to the criminal procedure. So this is my position. As for my ethics, yes, I admit I can be honest, sincere, and I can express my position. And unfortunately, we see in which society we live and what it leads to. I always fulfilled my duties. I was integral, honest, fair. And why is the question that the bodies of High Council of Justice said that I wasn't like this? The only thing... Olena Ivanivna, please stop. Okay, thank you. Okay, we are all in a stressful situation. Please do not worry. Please help us just clarify certain conditions. Given your answers, I want to have more details. So this disciplinary sanction in 2018 was connected with your understanding of procedural legislation in such a way that when the question on self-recusal is decided, you should not give this question, as you think, for the approval by the other court. Because as you think, there is a European legislation that should be guided here. Okay, so I will continue the question. Please tell us, do you think that in the procedural legislation of Ukraine, the question of how should this self-recusal of the judge on the case should be tackled? Hasn't it been tackled at all, or hasn't it been tackled in your way? No. Okay, if we take the norms of the criminal process, it says the order for recusal, and the order for self-recusal is not defined anywhere. Apart from that, the procedural code does not contain any norm that would state that the court or the judge can produce some procedural documents as the application.
Thank you. I'd like to follow up on that, and from what I can understand from your responses for the last 9+ minutes, you don't believe that the disciplinary system was correct. You still believe that you were correct and they were wrong. Is that true? Yes or no?
Так.
Yes. Yes. Yes, you understand me correctly. I just think that in this situation, they didn't study it thoroughly, and I would like to emphasize.
We understand. Just let us ask the questions, okay? And I only needed a yes or no answer on that. And that goes for the discipline in 2018 and also in 2024. There's another disciplinary action.
Так.
Yes. Can I clarify?
Просите пояснити коротко.
Okay, briefly. Yes, so there was the disciplinary action in 2024, and this complaint, I unfortunately upgraded HCJ, also selected one of the claims that were submitted, and they didn't study that issue properly either. And they said that I was, despite the fact that the case was under consideration for 1 year, they have, accused me of misconduct. So I provided the explanation. I actually appealed on this case, because I had a COVID and there was a big gap of time that I spent on the sick leave. And apart from that, It was also in the courts of appeal, and there was the decision made that was left without consideration, given that the representative of the defendant had no authority. So the colleagues decided it this way. Maybe they didn't read it properly. I don't know. I appeal it. And I think this is an obstacle for for my professional advancement, but somehow it happens. Thank you for your answer, but I would like to follow up. Tell me, after it was decided for disciplinary action, and we right now found out that it was due to your different interpretation as the conclusion of HCH, the question of recusal. And so, as of today, on self-recusal, do you see it as you see it for yourself, just like before, which already brought the responsibility? I continue doing it in the same way because I think the court approving the decision is to be unbiased and not to depend in no way. As a judge, if I decide that I cannot go through this case, that no judge, my colleague, on no grounds can say if it's objective or how I feel it. If these are my friends, my relatives, and even if me as a judge, I can make the decision and I'm competent enough and I have knowledge and this decision is truthful, but from the point of view of the observer, this decision will be approved. I live in a small town, people know each other. Okay, thank you. Unfortunately, we are limited in time. So you think you continue acting within the current legislation using your position, yes? You solved the matter on the self-recusal and it's not considered as it is seen in the procedural legislation. I see. Okay, let's continue. This is your position. It's clear. After, in 2018, there was the disciplinary action and there was the decision that made on your dismissal and sending you to the School of Judges. Did you doubt this decision by the HCJ? Me personally, of course, I disagreed with it. I appealed to the Human Court, to the European Court of Human Rights, but the decision was rejected, overturned. Okay, I see. As for 2024, the third disciplinary chamber of HCJ again instituted disciplinary action against you. So, but in this case, the case that ended in self-recusal had hearings for over a year. That, in opinion to the body that studied this question, led to violations of the procedural terms. Can you tell us? Yes, unfortunately, I comply with the reasonable terms. I respect them, and I use them in each case. But unfortunately, we have lack of human resources in Ukraine. Plus, there was pandemic, and this was by mistake. The HCJ, the third disciplinary chamber, have calculated these terms, despite the fact that there were the, reasons that I spent 80 days at work and 60 days I postponed. So I tried to act in humane way because people who came to me, they had the order that was in Russian, and I asked parties to bring it into accordance. So out of respect for the participants, I gave them the chance to have access to the court and gave the parties the possibility to provide the good documents that would serve as grounds for me as a judge to consider this case.
As I live in Ukraine, I respect Ukrainian language. There is a law. And I think my country, my people should know and must know the language. And judicial system imposes at me duties that I should consider all the cases only in Ukrainian language. Thank you so much, Ms. Olena. we follow the same principles as you. But the question is about the other fact. So if we cite there was a statement in 2020, during some time you conducted some procedural actions. For example, you left the statement without consideration that, and then in 2021, when you continue to work on this case, you announce self-recusal. So don't worry, we just want to find out all the conditions. So in a year, again, you had self-recusal. Why are we talking about the language, etc.? So about the language, I would say that after the cancellation of such a ruling, so the Court of Appeal didn't agree with the motivation on language. So they thought that this power of attorney in Russian language could be there. But this is the right of any judge to decide it. So they thought and they considered it is a document that can be used for proceeding. As for myself, when I appointed consideration of the process, my secretary came to my process and I couldn't, with the secretary who worked with myself for 3-4 years, I couldn't provide this decision, because from the point of view of external observer, I cannot take a decision as employee of the State Executive Service was my former secretary. So I involved here a statement that she was my former secretary, and I announced self-recusal. It was my decision. We are forced to stop you here. We understand that there is load, there is work that you have to perform, but the question was just in the fact that there was just a year of procedural action and then there was self-recusal. I'm sorry, but I cannot change it. So maybe you should have announced this self-recusal before. But I decided it when my ex-secretary came to me, because before she didn't appear in front of myself. Thank you so much. Thank you for your answer.
Thank you. Thank you for answering the previous questions. I'm going to reiterate a statement that I think I made earlier and has become, very obvious in the responses that you've just given us. It's clear to me, and I think maybe the other members here, that although you had decisions and opinions by the High Council of Justice that declared you to be contrary to the rules that should govern judges with recusal and timelines, etc., you don't accept that as valid. Is that a true statement?
Я не погоджуюсь.
I do not agree with the legal position of the High Council of Judges, because it is in controversy with the rationale. Because
Can I stop you right there? You've answered the question that you do not agree with the High Council of Judges. Now, here's my next question to you, or statement. You tell me if you agree with this. Whether a judge agrees or disagrees with the decision of the High Council of Justice, and once the disciplinary process is over, in other words, any appeals are taken and they go against the judge, etc., you are bound by the decision of the High Council of Justice with regard to those topics. Would you agree with that?
Безумовно.
yes, I am bound to it, but my legal position hasn't changed, and it won't change because it is my logical, state and sound and firm position. and to take another position just as High Council of Judges says or journalists say, I can't take it because this is my perception of the world. And
You recognize what the High Council of Justice decreed, and yet in your performance as a judge, you still feel obligated to do and to perform your duties according to your interpretation of the law and the ethics. Is that true?
Я
yes, I announce my self-recusals as I have done it before, because norms of criminal procedures need to be clear, understandable, and the order should be done in the legislation. There is a gap in the legislation. I also addressed the Member of Parliament with the fact that we need urgently to change the administrative code, and criminal code should be clarified, because when this practice started, there were two approaches. Some people considered self-recusers for other judges, and some of them did it by themselves, because there is only...
Thank you. I'm just going to reiterate your reasons, what you believe. At this point, we're not investigating whether or not, and we don't, it's not relevant to us whether or not you have a certain legal position, because we know what the High Council of Justice and the disciplinary system has said. And that binds you. That dictates how you must perform. But what I am hearing from you, that you do not agree that you violated the rules of judicial ethics during any of your court hearings. Is that a fair statement? Just yes or no?
I do not violate, and I haven't violated anything. It was just my position. I have right, I am entitled. As for the Article 10 of the Convention, I can express my position. It can be considered as irrelevant by somebody. But
Answering that question, I appreciate that. We all appreciate that very much. Are you familiar with the Bangalore Principles of Judicial Conduct?
так.
Yes, you are. Okay.
yes,
State what you believe to be the main principles of the document which should guide judges. What's your understanding?
integrity of a judge, adequate behavior, and trust of the society. Behavior of a judge shouldn't be doubted as for his or her decisions.
Thank you. Thank you. Let me kind of switch to a different area. Do you follow the rules of ethics when communicating with other judges and other court employees while you're performing your duties as a judge?
I'm trying to do it. I'm trying to follow these principles, but sometimes I am worried, and because the legal system works in a very weak way. In the consequences and in the conditions that I have been posed, I perform my duties, and I addressed many times to the supreme judicial power, but there is no reaction. Maybe there should be some reforms. There are a lot of reforms, but they do not justify themselves, because we cannot work like this when there is no secretary of the judicial hearing, when there is no equipment, when there is know a person who is in charge of the trial. So it's very difficult to work like this, especially in small towns when a lot of people are related in between themselves. And this, maybe I talk a lot today, but local judges of towns, they are under the big pressure of disciplinary actions. Legislative, I have already 20 years of experience and I would like to retire, and I could retire, but I would like to do something for this country. I have my family. I would like my grandson to live in this country and to be honored to live in such a country. I want people to make believe in court, but if we don't have it, so when I was with 17 years experience as judge and I couldn't during the 7 years to impose a criminal proceeding as for disclosure of my personal data, because a lot of rights were violated, but this is not a question now. The question is that it is very difficult to work under the pressure of disciplinary actions and sanctions that I impose to judges. I am here in front of you.
Stop you right there. So what I understand is that you do not agree with the sanctions that have been imposed upon you and the basis for those sanctions. That's fair. Yes or no?
Не погоджую.
Okay.
I do not.
Okay, is that the reason why you failed to enter the information in the Judicial Integrity Declaration of 2018? You failed to mention the disciplinary decision of September of 2018. Is that because you didn't agree with what happened? Could you answer just?
Так.
Yes, okay, all right. Even though you were bound to do that, you were required to do that, to declare the information. It's called the Judicial Integrity Declaration. Whether you agreed or not, you were required to enter that information.
I am sorry. Tell me please about which declaration we are talking now. When we talk about disciplinary action, I related it with, well, I was late in 11 hours. It was about my property state because the site didn't work, didn't function, and I informed it, and there was administrative protocol of law enforcement organs based on the document. It is about integrity. It's about integrity declaration, and the fact that you didn't mention about the institution of disciplinary action, and you talk about another declaration. So when there was the disciplinary action, this decision didn't enter in vigor, and when I was supposed to present this declaration, the decision haven't still been in vigor, and I appealed for it. As today we conduct a dialogue for 2024, I again have disciplinary sanction. And if you now asked me whether I have disciplinary actions, I would say that yes, there is instituted disciplinary action, but it didn't enter in vigor. As we can just talk about it, but as for official document, when we talk about integrity declaration, I couldn't.
Stop, please, stop. Thank you.
Послухайте, будь
Excuse me.
ласка, члена ДГ.
Just listen to the expert of the AGE. Don't worry, and then calmly respond the question.
You've made it very, very clear that you do not agree with the disciplinary action that has been taken against you throughout your career, correct? All right. So your belief is unless there is a final determination, in other words, the appeal is over and decided, you're under no obligation to report on your judicial integrity declaration. Is that what I'm hearing from you?
Так,
Yes, as this decision hasn't entered into force.
Understand that. Okay, I just wanted to make sure that I understood your rationale for not including it.
Yeah.
All right, that's not what the High Council of Justice would say, but that's what you believe is your right to do, correct?
Рішення ВРП має право.
So the decision by the High Council of Justice can be appealed. And I had a hope that High Council of Justice will reconsider it and cancel it. I couldn't even imagine in a nightmare that it will be without changes, because there were no reasons for institution depletionary action.
In fact, there was, go ahead, I'm sorry.
Дякую. Ми
Thank you. We understand in which state the country is, the judicial system is, but please focus on the answers that we would want to have. I asked you whether you doubted about the decisions of the High Council of Justice. It was about the first disciplinary action, and you said no. And now you say that I don't know whether it will enter in vigor and you will appeal it, and you say that as it is being appealed and it hasn't entered into vigor, that's why you mentioned about it. So where is the decision? You haven't appealed to it, or you don't know how to do it? Thank you so much. Thank you for your question. I will try to be concise, because we are legal experts, and if there is a decision made by the court of the first resort, and High Court of Justice, it was the first resort court, it can be appealed. So the decision has been taken in September, and it was reconsidered by the High Council of Justice in February. I mean, there was no decision in vigor that gave me possibility as legal expert do not include it into integrity declaration. If it had been filed, so I had no necessity not to show it, because a lot of legal experts know me and they observed me. Okay. So now I want to pass to the next block of question, and this block is related to the ethics, judicial ethics, and I would like to ask you. So here I should quote some questions that were in the documents. We know that trials are fixed. We know what people say, it is all recorded, and we can listen to it. So it is written that in civil case 486/1056 there were such words. This is information officially obtained by the advisory group. There is such a confusing tautology here. Some legal virtuoso wrote it. What has performance of notarial action got to do with it? My impression is that you wrote what they were seeing. Whatever norms caught by the eyes, they set them forth. This is not a motivation of the lawsuit. It is just a set of some, I do not know what call them. You are describing some incomprehensible nation. What kind of certificate is this, like in a stamp or everything? Are they testing me or something in the case? Can you just comment on these your words?
Що ви їх брали, може таке й було. Люди ж
Well, I can't say that I haven't did it, because different people come to us, and the first resort court is where you face different people. And unfortunately, I think that you will agree to me, or maybe not.
Currently, the legal universities are giving the diplomas to lawyers, and we have not very good professionals. Let's not generalize. Let's stick to the question. Sometimes, Lena Ivanivna, we don't speak about the level of competence, right? If we speak about ethical conduct, and can such expressions be used in the court's hearing when we were collecting the information, and one piece of information that was clarified on the candidates to the groups of experts. And one piece of information is what I just mentioned. And I just wanted to ask your opinion on the how ethical is it? Well, perhaps I shouldn't have asked this in this way, but how can I explain to an ordinary person? But how should I have said it? So you explained in plain language. Yes, I wanted to explain it in plain language. They said that they communicated with their lawyer from Kyiv. And I gave her a short break and tell her, please find maybe free legal aid or look for the specialist in the sphere of law. Okay, I see. We understand. So continuing this block of questions, I would like to ask you the following. Sometimes we face the cases in the registers of the judicial decisions. There are the court documents with some circumstances described that draw attention. And one of the decisions on the self-recusal, which you have a very categoric position, you have specified that you do not want to give the questions of self-recusal to some specific judge, or because this judge is using alcoholic drinks or abusing alcoholic drinks for some time, and you think that it's unnecessary for her to tackle this. And how can this question be in line with the norms of ethics on account of your colleague? I beg your pardon, but unfortunately, she's abusing, you're saying, right? No, I just want my case to be heard and the decision to be made from the point of view of the healthy court. But if the person has flaws, it must be responded to or tackled to by the state. Okay, we are saying that you tell us your attitude to the court ethics, but don't tell us that somebody is abusing or not. This is your position. But in the official document under the case number, you have specified that the case on the self-recusal can only be considered by such court, cannot be by such court that is abusing alcoholic drinks. So you do not trust the consideration of your application on self-recusal to such a judge. I think I did the right thing. Okay, thank you. We heard you. Thank you. So, do you confirm that you wrote and you think that your behavior was appropriate? Yes. I think each person who goes to the court, they want their case to be considered properly by the sober court.
A series of questions here, and they relate to your personal performance as a judge. But do you agree that the personal performance of a judge is not just about personal performance, that it reflects on the entire judiciary? Would you agree with that? That your behavior, how you conduct yourself on the bench, how you talk to litigants, lawyers, court personnel, colleagues, it all reflects not just you, but the entire judiciary. Do you see that?
Так, погоджуюсь.
Yes, I agree.
When you are speaking intemperately, whether speaking to litigants and lawyers and clerks, etc., or putting your thoughts in writing, in documents that are part of the court record, would you not agree that that doesn't speak well for the judiciary? The things that you have said and the things you've put to writing.
Я розумію, що воно відображається, але на превеликий жаль,
I understand that it does, but unfortunately, if the judicial system does not respond to the challenges, and it should, and to take the following measures, but not to enable to continue and not to solve them. This is my personal opinion. If there is a problem, it has to be tackled, and it's impossible not to.
Isn't there a process for tackling changes to the rules, the ethic rules, the other rules that govern the judiciary? Isn't there a process to address, to do that?
Ну, є
There is the code of the ethics of the judges, and each judge is to comply with it. Do I understand you correctly? That asking me this question, it's just that I realize that you're trying to transfer the responsibility on me why I wrote it this way. If I spent years with such people around me, and if I don't do this, and all people fear and are afraid, so will anybody say about this? I don't think so. If there is a problem, the court system is to tackle it. Despite the fact that when I held the position of the judge and having worked 20 years already, we have undergone 7 reforms, but none of the reforms, even the ongoing one, does not give the good results, the appropriate results. And I would really, really want for us to understand these reforms and to work in one direction.
I understand that you don't agree with the way the judiciary is being run and some of the rules and some of the perspective of the High Judicial Council. You're dissatisfied and you think that stating it in documents is important to let the public know that you don't agree. Is that fair to say?
I beg your pardon, I can emphasize one more time. I wouldn't want the judge who is under alcoholic impact would tackle the question.
You've made yourself very clear on that. That's not the question. Okay, let me now ask you how you transfer that attitude, that belief, to the Constitutional Court of Ukraine. How would that be? How would that fit in with the role of a judge on the Constitutional Court of Ukraine?
I'm fair, I'm just. I think that next to me, there will be no people in the Constitutional Court of Ukraine who can abuse alcohol. Maybe some complaints will be filed. Maybe something will not be written in the right way, but it's just that there's a very big gap between just the regular people and the Constitutional Court. And the problem is that our representatives of the court are not the first instance courts who get there, but maybe I will misuse the terminology, but we have white collars there, the people who have never communicated with people directly in the first instance courts. They have never been in the situations my colleagues are facing, the first instance judges, and being for years near the door waiting until they call me in, me and my colleagues looked very pathetic, and they were shivering in front of the colleagues who were holding the chairs of the High Council of Justice, and they would, reprimand them and so on. They were afraid to say anything.
Ma'am.
То ви мене хоч як Ісуса
Ma'am,
Христа
stop.
розпинайте, я вам все одно буду 1000
I will tell you for 1,000 times what I think. Sorry for me being emotional, but the court system, the judicial system over me, the judicial system has been experimenting with me, and I have exhausted all defense measures.
You're not answering my question. I'm not asking you to justify or give me reasons why you have found fault with the system that you are currently in. We all get your position. We understand what you're saying. My question to you is, when you bring that attitude that you can be rogue, so to speak, does that fit in with the image, the performance, and the expectations of the Constitutional Court of Ukraine?
Я дуже
I'm so sorry. I did not understand your question correctly. Now I will explain. In no condition, I understand what I do. I understand who I'm going to work with, and I have a big hope that next to me I will have people, colleagues, and that there will be, and that no similar situation that I've had will be there, because it cannot be there, and it wouldn't be there if the judicial system worked properly. We understood your answer. Thank you, dear Olena. I have a question. Dear colleagues, I have a question. Vasil has a question. You have just accused your colleagues in front of Ukraine, your colleagues judges, that they can conduct justice being under the influence of substances, and you say that you can be responsible for each word that you say. So you have now left like the shadow for your team. So tell me, please, is there a documented fact that the judge or the team of the court, they conducted justice not in a sober position? Please, me as the member of the advisory group of experts, I'm asking you to answer this question of my deputy. I will happily answer, even though it's unpleasant for me to answer to this question. Unfortunately, they wrote in this in the media. We have a colleague who, due to his life circumstances, she abused alcohol and she made decisions. It did happen. This is documented. I did not make this up. There's a ruling. But then we did not have the HCJ. We had the High Qualification Commission of Judges back then. The High Council of Justice. No, the High Qualification Commission of Judges. Yes. We had many reforms. We had the Council of Justice. So you think you answered the question? Okay. Then I would like to add on the questions you were asked. For a few times, I quoted the specific questions, right, that would refer to certain cases or questions that are documented. Do you confirm that such circumstances exist, or do you doubt the existence of them, like as a record during the court's hearing and such quotations in the rulings that the judge should not act when he is abused alcohol? Such circumstances, I do confirm. Please tell us. During your answer, you said that the judge is to support the requirements for the position, that the judge is to adhere to the ethics. Do you think that you have now done just that? Tell us, did you just adhere to the ethics? Do you think that in these two cases you have adhered to the conditions of the judicial ethics? There are two components here. Just answer yes or no. Did you adhere to or did you not? From the point of view of integrity, yes. Okay, thank you. Okay, we accept your answer. Do members of the advisory group have more questions? Okay, Mr. Marek Zubik.
if Mr. Aleś Zala, President of AG,
Yes.
allow me to do
Yes,
so, I would...
please, Marek. Marek, as my deputy, please ask question.
Thank you very much. What personal qualities should a Constitutional Court judge have? Are there any differences from common court judges? What is your opinion?
Саме
The most important qualities, and this is my opinion, maybe I overestimate myself, but I think nobody can have an influence on me. I will stick my ground until the end. But from the point of view of my personal experience, from the knowledge of law, from the point of view of law, of my upbringing, given the surrounding that I communicate with, how I perceive this world, I think I act truthfully, fairly. I'm open and no pressure on me. Not every judge can work for 20 years. And my colleagues sometimes tell me that we are very surprised by you, but not by the way you work, but how you continue to live in this world, in this place where you live. Okay, thank you, Olena. The question of Mr. Zubik referred to the qualities necessary to become the judge of the Constitutional Court of Ukraine, but you start speaking about yourself. Please tell us which qualities, requirements, legislative or social, that there are for the position of the judge of the Constitutional Court. What is your vision? My vision, the judge of the Constitutional Court is to be independent, to only be guided by the rule of law, to defend the Constitution. All laws are to be in line with the Constitution, and to use their knowledge, experience, and to approve such decisions, to stand for the rule of law on the basis of his knowledge. Thank you. We see. And also, Sukhotska has the question.
But now you make such a definition of independence of judge. But this definition is a definition general, which is, common for all judges. The judge is independent, should work only in the light of law without pressure. But there are some details which are different for the judge of Constitutional Court and the ordinary judge. And how you see, what is your application to send to be a judge of Constitutional Court? What is the specific rules for the judge of Constitutional Court? Because the general, as you say, details are the same for all judges. All judges must be independent, not only constitutional judge.
The Verkhovna Rada and the President and the Cabinet of Ministers can refer to the Constitutional Court. Three branches of the government, each of them independent, and it would be very logical that the judge of the Constitutional Court is to keep this balance, and in no way to give up his independence for the benefit of someone else, either for legislative or executive body. This is my vision. This is my perception.
A final question, I hope. The rule that applies to judges as well as ordinary citizens in this country and in any country that follows the rule of law is to follow what the court of last resort decrees, whether that court of last resort be constitutional court, whether it is the highest court in the hierarchy of Ukraine, whether it's your High Council of Justice and any appeal from that, and that entity decrees, then it's incumbent upon judges as well as lawyers, as well as members of the justice system, as well as citizens, to follow the law because that becomes the rule of law. And yet, what I hear from you is you don't accept resort. You will put your beliefs that you are acting with integrity over what the final decree is from the court of last resort.
Thank you for your question. I will answer you. If we talk about the Grand Chamber decision, I am very concerned about it, and with this concern, I would like to tell you my position. There is the row of decision from the Human Rights Court that passed through the Grand Chamber, but despite all this, the citizens of my country, they suffer and they pay for the violation of the human rights. Please answer the question. You had quite another question. Please. I continue. Can I? And please my answer.
Rather simple. And that is your respect and your adherence to the rule of law as decreed by the courts, whatever institution the courts are, of last resort. Do you embrace what those courts have decreed and incorporate it in your the way you perform your job? I'm sorry.
I'm sorry. If you talk about my case, this is a general question, your attitude. Yes, all the legal positions of the Supreme Court and everything that is not relating to myself as judge in my taking decisions and imposing of the higher resort judges of their opinions, because we have such issues that when European Court of Human Rights said that resolution was written by the President of Ukraine, it had key role in this decision. And European Court says that we do not separate power branches. Thank you so much. Are there any other questions to the candidate? Because we run out of time. That's why, if there are no more questions, I would give opportunity to Ms. Volkova for her final statement, where you, Ms. Volkova, can express your thoughts and opinion. 5 minutes, and we're finishing. I express my gratitude for this floor. Dear colleagues, dear representatives of the group, this is the only chance in my life where I can justify my activities. And today, in front of you, I would like you to see me as I am. And I stand for the independence of judges, as in which each judge should believe in. When there are years of consideration of the cases, for example, I give you an example. There are people that are in the role of suspect or in the role of accused for 15 years, and there are no procedures. I am innovative judge. I want to change something. I want to convince my colleagues in some good things, that there are amendments, there are changes. That why in some cases we can make self-recusal, in some other courts we should just pass it to our colleagues. And now I address you. I have never done illegal. I have never done any bad things. The only thing I have that I have been in the team when I appeared in such situations. Each time I did and conducted myself legally in an honest way. I addressed to the High Council of Judges as for the pressure towards me, and in 2010 this decision was confirmed, but to the High Council of Justice I addressed them 5 times. In 2 cases, I'm sorry, Miss Olena, we gave you possibility for your conclusion remarks to express your position as candidate of Constitutional Court of Ukraine, and don't tell about your life and your story. Yes, I just give you the evidence. I want to say that I am sincere, I am open and transparent. You can trace all my actions and you can see that I am telling truth. You can have some doubts about me, but please believe me. And the country will. So glory to Ukraine and glory to heroes, because my son-in-law and my assistants, they are in armed forces and they are fighting for ourselves, they are fighting for our future, and my late relatives from the heaven, they see it and they believe in Ukraine. Thank you, Miss Olena. We believe in victory, we believe in what's going on, and thank you so much for your sincere, for your emotions. We understand the state of each of us, especially we understand the state of women. So thank you so much. The interview with Miss Olena Ivanivna Volkom is closed. So we wish you success. Take care. Thank you. Believe in me. Take care about yourself. Take care about yourself, and let's have victory as soon as possible. There are some amendments to our agenda, and after the break at 2 p.m. we will hear Ms. Denisenko and after Ms. Halamai, because Ms. Halamai is from Lviv and she asked just to change the order. It won't influence and impact our timetable and schedule. That's why now we will have internal discussion. Please switch